Show are those of the show personalities and guest alone, and not those of Vic Canellis Media Group, its parent, affiliates, or stations. VCMG Live is not responsible for any content, information, or opinions expressed. User bears full responsibility for their reliance on such content, information, or opinions.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Hi, Steve. I can see you're talking, but I can't hear you.
What's happening? Can you hear me okay now?
Yes.
Okay. Remember, I told you,
Thank you for the intro.
new owners. There's a lot of new equipment and everything.
Okay.
Okay. We are back. We're here with the Ask the Expert show. Many of you do not know we have a new owner for the station now, and they're going to be doing a lot of incredible upgrades to the station. You can hear us on 96.9 FM, 95.3 FM, and our big station, 1470 AM. So tonight is our Community Association Law. Robert, the phones are already going crazy already.
Well, that's not a surprise, right?
Yeah, I know, but this is like kind of early. So people don't go away. We just want to introduce to everybody to Kay Bender Rimbaum show with Robert Kay. And Robert, it seems like more and more people are finding the show. Tell people about Kay Bender Rimbaum.
Well, Kay Bender Rimbaum, as you say, is a law firm that specializes in the area of community association law. One of our offices in Pompano Beach, Palm Beach Gardens, and Tampa. We provide all aspects of representation to community associations, be it providing opinions as to requirements under their governing documents, pursuing unpaid assessments, negotiating contracts with third-party vendors, addressing defective work that's been done either by a developer or by contractors after owners are in charge, assisting in turnover from developer control to owner control. Anything a community association will address on a day-to-day legal basis, things that we will assist with.
Well, you do so many great things. You know what, Robert? We're going to go because we've had some people waiting for a while. If you don't mind, we're going to go to the phones.
Let's do it.
If you'd like to call here, you have a question for Robert Kay, The phone number here is 888-565-1470. 888-565-1470. If you are a board member, if you're a management company, if you are a owner in a condo or HOA, and you have a question for Robert Kay, board certified Robert Kay, give us a call here, 888-565-1470. Let's go to Don in Deerfield.
Sir, can you hear me fine?
Yes, go ahead. Go ahead.
Okay. Yeah, I'm a resident in a condominium here in Deerfield Beach. My question has to do with the reserves, particularly switching from straight line to the pooled method. Our association in the year 20 decided to switch from straight line to pooled. But when they got the approved vote, instead of covering 97,000 for that coming year under pooling, they added or retroactively took all of the straight line that had already been accumulated over previous years and converted it all to pool. And I don't see anything in the statute that allows a retroactive application of that. Can you give me a hint on whether they handled that correctly or not?
Well, it would have depended on how the vote was presented and whether or not that aspect of the existing reserves was included in the question presented to the unit owners. But as you may be aware, the statute allows owners to vote to change the use of reserves from what they were originally held for, and doing so could be to put it into the pooling with everything else going forward. So you would have to look carefully at that language to see if that was done. If it wasn't done, then there may be a problem with what they've done.
Well, the ballot, sir, read convert existing reserve funding from straight line method to the pooled method. And that's the way that ballot presented it. It's my understanding that if you're going to change a straight line to any other use, you have to have a specific vote to do that. So it occurred to me that they should have a separate vote to actually change the existing straight line to convert it. They just took the what would be the right way to say it? They just found it convenient to just go ahead and take it. I'm
it sounds
they needed a vote.
It sounds to me that they made the attempt to do what you're saying, but the language they used was a little bit vague as to how it would be applied. They should have been more specific as to each of the line items that were in the reserves that were going to be pooled together. And it would make sense to represent the question, but it could go either way if challenged.
Well, that's part of the problem, I guess, with some of the law and some of the circumstances. It can go either way. Thank you, sir. I appreciate your opinion.
Thank you, Don.
Thank you for listening.
Let's go to Marvin in Fort Lauderdale. Hi, Marvin.
Yes, can you hear me?
We hear you fine.
Okay, great. I live in a condominium association in Fort Lauderdale, and the Declaration of Condominiums specifically says that every 1 and 2 bedroom unit is entitled to one limited common element parking space, while 3 bedroom units are entitled to 2 limited common element parking spaces, where the entire parking area is considered a common element. Some owners are now claiming a right to 2 parking spaces, even though they live in 1 or 2 bedroom condominium units, in violation of the terms of declaration, claiming that either a prior seller or when they purchased originally from the sponsor were told, but not in writing that we can find, that they're entitled to 2 units. Can the association today notify those who are claim limited common elements in violation of the declarations that they cannot continue to so use those common elements?
As you have described it, Marvin, I would tend to agree with the conclusion you've reached. If there's nothing in writing that these owners can produce that indicates an additional right to a second parking space, then the association would have the authority to notify them that they only have the right to the one and that the other one is regular common element parking, open to anybody. Unless the documents provide for a mechanism for the board to assign parking to the individuals in addition to the one that was entitled, or provides for a means for owners to transfer between them parking spaces, then it's pretty much as you've described. It's 1 for the 1 and 2 bedrooms and 2 for the 3 bedrooms.
Okay. May I ask a second question, possibly?
It's going to cost
Go ahead,
you an
Mark.
extra 20 cents.
Okay, you got it. I'll throw in a quarter. All the parking spaces in the limited common element are indoor designated parking spaces. There are no commercial spaces. Can the association remove the previously designated handicap parking spaces and allow those who are in need to apply for an accommodation to use a parking space near an elevator or an entrance door?
If somebody makes a request for a reasonable accommodation in parking because of a legitimate handicap situation, then the association is required to the best of its ability to accommodate that if there's available parking to do so. I don't think that you necessarily would commandeer existing handicap spaces. Those are supposed to be maintained for as guest parking more than for the residents, because the residents have their assigned parking. And the handicaps on the site plan.
Well, here, our guest parking is all outdoors, and the handicap parking is all behind the gate.
Well, if the handicap's only located where owners have access to it, then, and none of them are assigned, and then it would tend to be a free-for-all for the handicap parking to anyone who has a permit. So if the board wanted to assign those to someone who had made the request, I'd have to know more from the documents whether the board has the ability to make such an assignment. It's possible that the board could treat it as like a rental of the common element at a nominal rate and get around it that way, but we'd have to see the documents to say for sure.
Okay, great. Thank you so very much.
All right,
Thanks,
for
Marvin.
listening.
We've had a couple people drop off. That's okay. Just give us a call back again at 888-565-1470. It's 888-565-1470. We are here right now with Robert Kay. He's with the K. Bender Rimbaum. If you want to give us a call, call us right now, 888-565-1470. We're going to go to break. Robert, give everybody the number at the office if they'd like to contact you there.
You can reach us at 800-974-0680 or go to info@kbrlegal.com by email, or just go to kbrlegal.com, our website, and fill in a contact request form on the opening page, and we'll get back to you that way.
And it's a great website. It's got so much great information on there. We're going to go to break. When we come back, we'll have more with Robert Kay, senior partner at K. Bender Rimbaugh. We'll be right back.
Matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembam is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembam today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. This is the Ask the Expert show. We are here with Robert Kay, Community Association Law, board certified. The number here, if you'd like to give us a call, is 888-565-1470. That's 888-565-1470. What we usually do at this time during the show is Robert's going to tell you about all the certifications, all the seminars that they do, which means K. Bender really gives back to the community. What do you have coming up for July?
Well, Steve, on Monday, July the 11th at 12 noon to 1:30 p.m., we have a webinar with Michael Bender hosted by CAI's Florida Legislative Alliance, which will be going into the new condominium safety legislation update, the statutory changes to condominiums and cooperatives that address the structural issues and reserve issues that people have been talking about for many, many months that the legislatures adopted last month. Then on July the 20th at 5 o'clock to 6 o'clock on a Zoom presentation, we have Lisa McGill presenting the screening process, how to develop procedures and train your committee. And then on July the 28th at 4 p.m. to 6 p.m., we're doing the other Zoom seminar on homeowner association board member certification, which will be taught by attorney Emily Gannon out of our Pompano Beach office. And then I'll throw in August the 4th, since I won't see you until August the 4th again, at 12 noon to 1 p.m. We have part 2, new condo inspection bill, get your questions answered, hosted by Campbell Property Management, featuring Michael Bender via Zoom. For these upcoming presentations, go to KBR Legal, click on the calendar, and then choose the one you're interested in and register so that you can get credentials to log in.
Busy month. Somebody just wrote us, Robert, certification classes coming up.
Yeah, the board member HOA certification is on July the 28th from 4 to 6. We have a condominium one. We can talk about that next month.
Okay, very good. So we're going to go, if you'd like to have a question for Robert, 888-565-1470. We also ask you to, if you have a question, you can send it to us, and this is one of our biggest months. We had more questions given to us. So let me get started with those. This is from Ben in Pembroke Pines, Robert. He says, our buildings are 35 years old. I already know what this guy is going to say. And we're a condo conversion back in 2003. Do we need an inspection due to the age of the building?
Well, assuming their building is more than 3 stories, or 3 stories or more,
Right.
the answer will be yes, because the trigger in the statute is 30 years. The county's 40-year inspection hadn't triggered for them yet, but there is an open question with the legislation whether the 40-year inspection would be sufficient if anyone's had it to avoid. And the general consensus at this point is no, they still need to do the new milestone inspection, as it's called under the statute, because it does involve more of the structural components of the building than what the 40-year inspection might have done. So they have until the end of next year to get that done, but as we've discussed, since it has to be by a licensed engineer or architect, and there's only so many of them around with so many buildings that they're going to have to be doing, it's probably good idea to be in touch with the county or the city, which is again an open question, which is supposed to notify each of the buildings at some point of the need to get this done, but it isn't necessary to wait for the county to notify. It's going to happen unless the legislation is changed in the next session next year. So good planning would be to get started on at least arranging for that at some future date, not too far down the line.
Let's go to Paul in Stanford. Hi, Paul. Paul, are you there? I don't know what happened to Paul. Let me go while we're waiting on Paul. Paul is there? Hello, Paul. Okay, he must have had to use the restroom. Let's go to Bill in Boynton. This is one of our letters that came in. It says, can board members tell owners about the new laws, or is that considered practicing law without a license? Must any info come from the condo attorney?
Well, the info that the board receives should come from the association attorney. The board is able to communicate that to the unit owners, but as we all know how the telephone game works, when somebody tries to transmit what somebody else told them, something gets lost in the process. So it may be wise to involve the association attorney at the point when the board wants to begin addressing this with its unit owners. That's a business decision for the board to make. If they feel comfortable and able to address the complexities of what's involved, then certainly there's no legal impediment for them doing so.
Okay. Let's try Paul again in Stanford. Hi, Paul. Paul, are you there? Okay. We're trying to get Paul back on the phone.
Can you hear me?
Yeah, we can hear you now.
Oh, okay. I'm the president of an association where half our buildings are 3 stories, half our buildings are 2 stories, and we have one one-story building. How does the condo safety law affect us?
Well, I don't think it's addressed a situation that you've described. It just identifies buildings that are over 3 stories or more. So the 3-story buildings would likely fall within what the statute requires. And then the board will have to make the business decision whether or not to include the other buildings or skip them because the statute doesn't require it. There's not very many like you out there, I suspect.
What about the reserves requirements?
Well, the reserve requirements are written in a way that seem to apply to everyone, regardless of the size of the buildings and whether or not they're required for the milestone inspection. There are certain components which are still waivable, such as painting and paving, and some of the other items of $10,000 of deferred maintenance that aren't structural related, that are still waivable by the owners, but the vast majority is not going to be waivable in the future. That's what you're asking.
Thank you.
Thanks, Paul.
No problem.
Let's go to Gary in Miami. Hello, Gary. Gary?
Gary there?
Okay. Let's go to Susan in Tampa while we wait for Gary. Susan? Susan, are you there? Okay. I'm sorry. Again, this is, we've gotten a huge upgrade in equipment, and they're still, believe it or not, still kind of testing it out. But you're going to be able to, the quality is going to be upgraded. So we're just trying to tie together Gary in Miami and Susan's out there in Tampa. Let me just go to one of our questions on here. There was a board member of an HOA lives in a South Florida owned by a trust, Robert. Can he serve on the board or committee if he is not a trustee of that trust? Who can verify his trustee status?
Well, the way the statute reads on qualifications from a trust is that the only people that are qualified to serve on the board would be the grantor of the trust, the person who created it in the first place, or a beneficiary under the trust, so long as the beneficiary occupies the unit in question. The trustee doesn't necessarily have the right to serve on the board. The board should be requesting or requiring that a fully executed copy of the trust be submitted to the board and made a part of the official record so it can determine what the qualifications of the person being submitted into that position.
Okay. Hey, let's try Gary again in Miami. Gary, are you there?
Yes. Hi, can you hear me?
We can hear you fine.
Hello? Okay.
It's working now.
Are you suggesting that to go from transfer straight line reserves to pooled reserves, that you need a vote for each separate component?
If you're taking existing reserves and switching them, it needs to be clearly presented that that's the goal of the association, that it's not switching to pooling into the future and just future reserves, but all reserves inclusive of those that are designated to specific items.
Okay. That's my question. So,
Thank you,
hello?
Gary. Let's go to Susan in Tampa.
Yes, hello. Can you hear me?
Yes, ma'am, we can.
Yes.
Okay, my question is, we're facing, of course, the structural inspection, also replacement of the roof for insurance purposes. What can you tell us about our responsibilities upcoming for ELSS? We opted out of the complete retrofit a few years ago, and we understand that the ELSS system has to be in place by the end of 2023. Do you know any more about that requirement?
There haven't been any changes to the statute as it relates to the ELSS systems. So the timing you are facing remains the same.
Yeah. It's just hitting with so much at once with the structural inspection and those repairs, plus a replacement of the roof, plus the ELSS. It's going to be a huge special assessment facing us. So we were
Well,
hoping for
the
some
only-
good news in there somewhere.
Well, the hope I can offer you is that there's still going to be a legislative session between now and when the time for the inspections and the work to commence that might make some changes, recognizing the significant financial impact this is going to have on condominiums throughout the state, that they might be able to come up with a better plan to make it a little more palatable. So that's the hope that we are living with right now.
But should we go ahead and plan for the special assessment to cover all of these things?
I would say yes. You still have to plan as if it is as it is now, and until it changes.
Okay. Well, thank you very much for giving us that information.
You're welcome. Thank you, Susan. We have another line open at 888-565-1470. If you'd like to ask board-certified attorney Robert K. Bender Rimbaum, give us a call here, 888-565-1470. We have to go to a break. Robert, would you give everybody the phone number at the office?
You can reach us at 800-974-0680. You can write to us at info@kbrlegal.com, or you can go to our website, kbrlegal.com, and fill out the contact box on the opening page, and we will get back to you.
Okay, we're going to go to break. When we come back, we have more with Robert K. Bender Rimbaum. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rimbaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. This is the Ask the Experts show. We are here with attorney Robert K. We are doing community association law today. We do it the first Thursday and the last Thursday now, each month. So we will have another community association show the last Thursday of this month. If you'd like to call us, our number here is 888-565-1470, 888-565-1470. Now what we like to do is we always invite our listeners, because a lot of them are in the car driving home and don't want to be on the phone, so we ask you if you have a question for Robert, you can text them to me at 954-336-3761, or you can email us here. We're going back to our questions here while we're waiting for callers to come in. Let's go to Kelly in Fort Lauderdale. She wants to know, can a board do a special assessment without a vote?
The answer to that would be no. I don't know how they would do the board special assessment without a vote. There'd be no action taken unless the board votes for it. Unless their question is a vote of the owners, which isn't necessarily clear from the question, but the board has to vote on special assessments, either at a meeting or if they do it by a resolution, then they'd have to all sign off on the resolution.
Okay. Babs in Coral Springs wants to know, our community is in the process of getting a reserve study completed. How long do we have for all the reserves to be funded?
Well, the timing for funding of the reserves will depend on what the reserve study tells the board, because part of that study is to give a useful life of the particular component and an estimate of replacement costs. So you use those numbers to figure out how long you have to fully fund it, and then just plug it in, and that'll tell you how long you have. Some components may be within a year or two, some may be 20 years. So it really depends on what the report indicates.
Beverly in Delray Beach says, if our association has not collected any reserves outlined in the new law, does that mean on 1/25 those items will have to include the deficit?
Well, if they comply with the statute will give them all of the items. The reserve study report will tell them how much is required for each of the items and how long they have to put that together. And those would be included. Those items are part of what the reserve study will be looking at. So yes, they'll have to fund for that as well, at least as the statute currently is written.
Kaylee in Delray Beach, she's in a condo. When do our 2023 budget, are we required to include fully funded reserve accounts? When do we have to be fully funded for the reserves?
Well, the fully funding, again, is going to depend upon the reserve study report. If she's using the term fully funded, meaning that portion for that year, then you'd have to include whatever it is for that year. Again, as it currently stands, painting, paving, and some of the components that are non-structural that might be required to reserve under the statute are still waivable by the owners if they're desiring to do that, if the board chooses to submit it. Otherwise, they would have to be included in everything as well.
We seem to get a few of these. This next question, Brad in Pompano Beach said, we want to recall 2 members of the board. What are the procedures, and can there be retribution? Do we serve this to the board?
Well, the procedures for both condos and HOAs, as well as cooperatives, are in the statute, but basically there's 2 ways you can do a recall. One is at a meeting of the membership, or the other is by a written agreement. Most recalls we see are done by the written agreement method. There's a form that the Division of Condominium has on its website within the Department of Business and Professional Regulation. They have a form for condos, a form for HOAs, that is fairly self-explanatory, where owners would sign off on their specific agreement indicating which of the board members they want to recall or retain. And once the owners that are seeking to recall the board have collected a sufficient number of those written agreements, then they have to be served upon the association either by certified mail or a process server, that like you would a lawsuit. So often it'll be done by certified mail, and that goes directly to the association's official address. It could go to any officer of the association. It could go to the management company of the association. The registered agent of the association is an option as well. Those are all identified on the Division of Corporations website at sunbiz.org under the name of the association. So that's a nutshell of procedures for recall. Now, could there be retribution? That's not a legal thing that's contemplated. In practical terms, people are people, so that's a possibility. But it wouldn't be a legal retribution. I'm not sure what the writer has in mind there.
Gary in Deerfield. Oh, this has got to be one of your relatives, Robert. He said, I love your show. I never miss one of your shows, and I'm so glad you've added a new show each month. Our HOA has raised dues the last 2 years. Can the board do this without a vote from the owners?
Generally speaking, the annual assessments that owners are required to pay are to be adopted by the board without a vote of the owners. That's the board's obligation under the documents and the law to fully fund the needs of the association for each fiscal year. So yes, no vote of the owners would be involved in that.
Okay. Hey, let's go to Mike in Boynton Beach. Good evening, Mike.
Yes, I have a question. The new law says in the condominium building is less than 3 stories, then the legislation provides that in addition to annual operating expenses, the budget must include reserve accounts for capital expenditures and deferred maintenance for anything over $10,000. I have a question. Can you hear me?
Yes, we hear you fine. Turn your radio down. Mike, are you there? Okay. We lost Mike.
Well, the portion of the statute he was reading isn't new. I think that's been there all along.
Okay. Let's go to, here, Janice in Boca. She said, if a condo is towing with improper signage, would that make it an automatic win for the unit owner and the attorney fees paid?
Well, nothing's automatic. It would take legal action in order to have the entitlement to recover those damages and the attorney's fees. A demand can be made, and if the association voluntarily will pay for that and no litigation is required, then that would be like automatic. But unless the association chooses to do so, it will require the filing of legal action to get that to happen.
Okay, we just got through with the 4th of July weekend. Here's a text we got from Billy in Hollywood. My condo made me remove my flag on the 4th of July. What are the American flag laws for condos on holidays?
Well, the statutes provide that on specific days of the year, owner has to be allowed to fly a portable American flag, and certain of the armed services types of flags as well that are not larger than, I think, 4 by 6. And the days that the statute identifies as Armed Forces Day, Memorial Day, Flag Day, Independence Day, and Veterans Day. Those are the days that owners in condominiums have a right to fly an American flag where they otherwise wouldn't be. So if they required them to remove it on Independence Day, then they were in violation of the statute.
Okay. If you'd like to give us a call here, we still have a few more minutes. The number here is 888-565-1470. We're here with attorney Robert Kay of Kay Bender Rimbaum. Can a HOA, well, let me ask you another question because I just got this before I left. The condos, Robert, that have parking on the first level, and then the apartments are on top of the first level, is that counted? Is that counted as a level when it's 3 levels or more with the new law?
Yes.
Okay.
I mean, it is, the law is geared toward the structure of the condominium. And the lower level is part of that structure regardless of its use. So that is part of the calculation in determining whether it's 3 levels or not.
Okay. I promised this gentleman I would get this his question on it. This is Ben from Davie. Good morning. Your show gives me more valuable information than any show I've ever heard. I live in a gated community. Our gate has been broken for the last 4 months. It's supposed to be open 24/7. Who is liable for the gated community's break-ins?
Well, the association could have some exposure to liability if there's break-ins because the gate isn't working, but a homeowner would have to show evidence conclusively that the break-in wouldn't have happened but for the condition of the gate. Now, certainly it's a good indicator but gates don't guarantee that break-ins aren't going to happen. They are a deterrent, but they're not infallible. So the association shouldn't be having the problem, but these days with contractors and finding people to work is sometimes problematic, getting them to come out and fix things. So 4 months might not be considered an unreasonable period of time in today's current situation in the workforce. So it's going to be a factual determination based upon all the circumstances that come into play.
You know, how are people these board members going to find architects, engineers to cover all these buildings that they're going to have to start servicing?
Well, that's part of the issues that are being raised to the legislators, that, you know, it's a good concept, but practically speaking, it may not be workable given the limited number of qualified people to do the inspections versus the number of buildings that are going to be required in a short period of time. So initially, that's going to pose almost an insurmountable problem to many. So while there is time between now and when it's required, roughly 1.5 years, I don't think sitting back and waiting is a good idea anymore. I think that given the lack of providers, that it makes sense to try and get them booked as soon as possible, even if it's for several months down the road.
Robert, does your firm get involved with land disputes?
Such as?
Well, there is a property that somebody moved in. The owner, this is a HOA. The owner had been there for 30 years, and a new owner moved in and said the property line was not accurate, and he proceeded to cut everything down.
Between two owners, you're talking?
Yeah. So,
The association.
how do you dispute that?
Well, you'd have to have a survey to show where your
Right.
property line is, and that would be the legal basis for whichever side you're on. Generally speaking, the firm would only be involved if the association was involved. We don't generally represent individual homeowners
Right.
against each other. But that's what that sounds like, is an owner-to-owner issue.
But doesn't it have to go to court? I mean, they can't just start cutting down hedges.
I mean, technically, yes, except once the hedges are removed, then like, a lot of people have the mindset it's better to ask for forgiveness than permission. And so they would do the deed and then, I'm really sorry about that, but that could expose them to damages and possible punitive damages depending on the circumstances. We wouldn't advise anybody to self-help on it, although we've had condominium associations where owners have planted stuff on the common elements, enclosed their patios with bushes to make it private when it's part of the common elements. And it's been that way for a number of years. And while the association is no longer able to compel the owners to remove it, it's still common elements under the control of the association. The association can remove it themselves at their own expense. And we've had clients do that. And we've had owners who objected and call the police and bring legal action, but they're not going to win that. It's the association's entitlement to do that. So, you know, facts and circumstances are going to be important on these types of issues.
I'm trying to get all these questions in before we go off the air. Sunny and Sunrise. We haven't gotten many emails from Sunrise. If a board was elected using e-voting without resolution for e-voting, and the board has been operating as if they were properly elected, what recourse do we have to remove them?
You'd have to take that, either recall or challenge it to the division arbitration section, division of condominiums. But you only have 60 days from the date of the election to bring a legal challenge, and you have to send a written notice to the association and a demand for whatever remedial measures you think should be done in order to overturn an election that way. So the timing is critical.
You know, and Robert, let me just repeat it, that Robert is a senior partner at K. Bender Rembaum. Haven't done this in a while, but, you know, if there's a board member out there, if there is a management company out there, what would you say to them about retaining a law firm like yourself that specializes in association law? What would you say to them?
The area has become highly specialized over the years because there's constantly changes being made to the statutes, changes happening through case law. And if somebody isn't focused on that area and just does many other things and is a more generalist, they may not have a sufficient background or experience to fully address all of the issues that come up. And while they may ultimately be able to address it, it might take them many hours to understand and educate themselves in the areas that we deal with on a daily basis and address in a matter of minutes. So there's that aspect of it. The fact that our firm consists of 9 or 10 board certified attorneys in the area, that means that's a special status that the Florida Bar has put upon us. There's requirements of continuing education that far exceed what a general attorney is required to have, and it has to be in the specialized area that we're certified in. And the certification has to be renewed periodically. So there are those factors involved in why the board should be looking at an association attorney that has the experience such as those at K. Bender Rembaum.
Robert, give everybody the phone number and your website address again.
Reach us at 800-974-0680. You can write at info@kbrlegal.com, or you can just go to the website, kbrlegal.com, and fill out a contact form, and someone will reach back to you.
And somebody from your office will be here the last Thursday of the month at 6 o'clock. Robert, thank you as always. We'll see you again next month.
All righty.
And we'll see you all next week at 6 o'clock with more Ask the Experts.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.
The opinions expressed on the preceding sponsored program were strictly those of its host, guests, and callers, and not necessarily